I must say, when we talk of this is a conference on charting the right course for business. So, first tip I must give at the outside that if we, as business lawyers, want to be on right side, we must be punctual. This is my first advice to all of you. My problem is that I was told that the function would start at 3 o'clock. My address was from 3:15 to 3:30, 35, whatever. And I had fixed one emergent. I don't fix cases on Sundays, but I couldn't help it. And there's one arbitration matter I fixed at 4:30 today. I thought that I'll be back by that time. So I'm sorry because of that. I won't be able to speak what I wanted to speak in that at that length, but I'll try to summarize what I want to convey in few words and next few minutes which have at my disposal. So first of all, I welcome all of you on behalf of Mr. Anurag Batra because I know for me and in order to give me time, he has skipped his introductory lecture or introductory address. So therefore, I am welcoming all of you. This is, of course, as the function is about business world, and we are here celebrating the work done by various law firms dealing in business laws. And of course, that award giving ceremony would start later in the day. But before that, this conference is kept on charting the right course for business. So, but since I may not be there at that time, first let me congratulate all of you who are going to be awarded and who have won those awards. You have done really wonderfully well because I was a part of jury and I know, I mean, when we had the interaction with the persons who were the applicants for these awards, and I would say that India is now a place where legal words really its time has come, and it is being recognized all of the world as far as legal acumen of Indian lawyers is concerned. And we are here to face foreign lawyers also if they come and they start practicing, because we don't know when that happens or whether it happens or not. But if that happens, we will not be lagging behind. We have stalwarts here who can manage Indian legal landscape well, because they are not only doing such remarkable job within India, but outside India also, and they are getting recognition. I have seen quite a few international arbitrations which I am doing, and a few international mediation and other conferences, etc., also which I have been attending. How Indian lawyers are now given that kind of recognition and respect. So the times have changed, no doubt about it. And here, charting the right course for business, I would say here, of course, we are here not sitting as business houses, and we are not talking about the right course for businesses from the business houses point of view and what they are to supposed to do or what strategies are to be adopted. But it's a connect between the law and the business, which we are going to discuss. And as I have seen, I came here only and I could see the topics very well thought of and conceived and conceptualized. And I also see the panelists. I am sure that they are going to be, there is going to be very interactive sessions, and we will learn a lot from those discussions. I would try to give my preliminary remarks in the sense that, look, and it may be that this is what we have seen over a period of time, a person of my age. when I was a student, because I was a commerce student, students of economics. So I've seen business, studied business from my school days and college days, then in law also, and then in practice as well. But how there has been a paradigm shift in insofar as business laws are concerned. First thing which has to be kept in mind that look, there is a deep connect between the law and economics. In fact, if we want to see a prosper India, if we want to see the economies, our economy to grow or grow further, not only there have to be robust laws, economic laws, but the way they have to be interpreted by the judges as well, and what should be the economic approach in interpreting those laws. That is very, very necessary. I had the occasion and I had discussed that in one of my judgment, rather the first judgment, yes, that Shiv Shakti case, in which I discussed this topic, and thereafter in two or three more judgments also as Supreme Court judge, I had highlighted this aspect. Uh, what we see, as I was saying, in 1950 or 47, we got independence. In 50, our constitution, we gave ourselves that constitution, which came into force. And of course, that was a time in 1951, if you know, first 5-year plan. In those days, there used to be 5-year plans by the government of India, and what would be the economic growth and the how we should conceptualize and how we should see the economic growth in 5 years. That plan used to be made, budget would be allocated for that, and that I still remember as students of economics, we would read. But what I'm trying to say is that, look, when India got independence, there was hardly any industry in India, because we know the way Britishers plundered India and finished the business here. And it is said that and at that time, even there was no manufacturing unit even for to manufacture hairpin in India. So Pandit Jawaharlal Nehru, then he thought of that, and that was his first attempt and motive, that we have to see industrialized nation. And he thought of mixed economy at that time, if you remember. And it was his vision that, look, in order to establish some of the businesses, and in order to ensure that the backward areas in the country, they also come up and they also become industrialized area. So it should be mixed economy where the government should also play its role, because private business is naturally, normally profit driven. They may not go to a place which is Bokaro steel plant, how it came in that place. And there are so many such examples that naturally private sector would not go to that place and establish a factory which may not yield results or profits. So we had this, and at that time, another thing which started was that there were some key industries which the government thought at that time that it is the government which has to play a significant role in the development. And those were almost then taken over by the government itself. We should remember, of course, initially we had that insurance sector, but these were nationalized. Insurance was aviation, mostly over a period of time, run by the government only, Air India, Indian Airlines, etc. Even banks, they were private banks, but many banks were nationalized in 1969, 14 banks, then in 1986, more banks. So we were, that was a time where government, and I still remember in law, we had one course which was, we used to call public control of business. So it was more a control, public control, or the businesses were where the government will control, even the private business, how it is to be. And that is why we had all that license Raj, quota Raj. You could start the business only, you are given a license, you will be given the quota only, you can manufacture up to that extent. Even for export, you will be given the quota and you can export up to that extent. So those were the times. So from, as a student of economics, I know from laissez-faire economy from before 1947, of course, there was hardly any economic activity in India, but laissez-faire is where full freedom to the business, to the mixed economy. And much more controlled economy when, as I gave the example of nationalization, so many industries were nationalized, and the government thought at that time in 70s and 80s that there should be more and more government control. But then came 1991, when we ushered into the era of globalization. And at that time, it was found, I'm not going into the causes why it happened and all that. And as a student of economics or business lawyers, you will understand this. But then it was necessitated, and it was the vision of Mr. Rao, our president at that time, Nasimha Rao, and of course Manmohan Singh ji, who was the finance minister at that time, and they thought that our reserves were depleting. I think only 1 week or 2 weeks reserves remained, and at that time this decision was taken. But with this, as far as economic laws are concerned, there came a paradigm shift. All those license quotas, etc., went away. Economy was open to private sector. Today we have, whether it is aviation, whether it is insurance, whether it is telecom, which was all nationalized earlier. So all private players are there. And instead of public control of business, control is still there of different kind. And that is regulators came. If it is electricity, where it was earlier, even electricity is one sector which was totally, government sector only, private sectors are coming. But then they thought that, look, they should not have, these are some of the, whether it is telecom, whether it's insurance, whether all these sectors are there where there should be some control, but control should be by a independent regulator and not by the government. So we have the telecom regulator, we have the insurance regulator, and likewise regulators in all these fields. Another important thing which took place, that because of this privatization or globalization, when we ushered, we wanted more and more FDI. There have been more and more foreign collaboration, etc., because of which, and it was not happening in India, it was happening throughout the world. There were some countries like China who could still march over India because they ushered into this globalization few years before us. And because of that, they still, are ahead of us. Even when in last 10 years or 12 years, our economic growth have been little more than that. But what I am trying to emphasize is, insofar as legal field is concerned, the kinds of disputes which were there, they totally changed. I remember as a lawyer, when I entered, passed out law and entered practice in 1977, and I was doing commercial laws, arbitration, etc. But we used to have all those domestic issues only. In intellectual property, we use mostly it will be trademark, hardly copyright or trademark. But today, in intellectual property, there are more patent cases, international patents. In arbitration, it is more international arbitration, complex metric. So complexities of issues is going up. Our matters are international. So this is bringing another paradigm shift insofar as the laws are concerned, which I was telling you. What had been happening? Like you remember, everybody, about Arbitration Act. We had to say goodbye to our archaic law in 1940 and came out with Indian this Arbitration Conciliation Act 1996. But what is important behind it? It is based on UNCITRAL model law. What I'm trying to say is UNCITRAL coming out with model laws which are needed in a globalized era where the disputes and business are not now within the boundaries of one country. They are cross-border ramifications. So therefore, we also need, we had earlier, you also must have studied private international law, how to solve the issues of conflict of laws. But then why those issues at all, if there is what we call as convergence of laws, if laws are almost same. So this is one. Patent Act, there was a new act, changes in the act. Trademark Act, new act brought on what WIPO said or WTO said. And likewise, so many laws which change. We came out with recently IBC, our insolvency laws, in tune with what is happening in international law. So all these laws, that was one thing which I wanted to say, that the landscape as far as laws are concerned, they have changed. The way disputes have to be resolved under these laws, that has changed, totally changed, which we have to deal with. Another thing which I would like to mention here is that the dispute resolution, the ecosystem is changing. Maybe arbitration was always there, but as I said, that it was like, what kind of arbitration? We have in Chandni Chowk one this association of the business association of the traders, etc. Those kinds of small association will be there. They will be doing their arbitration. I mean, whenever the in-house arbitration, of course, Arbitration Act was there. But I said that the issues which we are now grappling with are totally different. And even in domestic laws, the totally different kinds of issues. The stakes are large, issues are complex, and we need expertise from lawyers' point of view also, and the arbitrators also who have to be. So dispute resolution system, which was earlier primarily confined to courts, municipal courts, etc., that is not there. If you see what is happening in, and I'll give you, as I said, for I would not be able to speak much because of lack of time at my disposal, but I always give this example, and I really marvel the visionary step which Singapore has taken. And their law minister was saying one day that, look, to somebody Indian, that look, in India you have gained in what you call when we talk of tourism, health tourism, that people come from the other countries because health system in India is improving. So they come even from Western countries because the medical facilities, they are very costly. So they will come here, they will be able to go around also and have their problems, health problems also solved or taken care of or treated. He says, we have gone with legal tourism. In next 15 to 20 years in Asia, and maybe we are competing with, you said that because Indians are coming, legal tourism, it is India. And three things, when I talking of dispute resolution system, which they have established on international basis, and which is need. And our system, we also going towards that. That is mediation, arbitration, and court. As court, I'm talking of a commercial courts. We also have Commercial Court Act, but at international level, they have SIMC, Singapore International Mediation Center. They have SICC, Singapore International Commercial Court, where I'm presently appointed as judge. So in their SICC, there are about 15 to 17 international judges who they have taken from all over the world. So I represent India. I'm lucky to have that they have appointed me from India. No, I didn't say for that. But the third was SIAC, Singapore International Arbitration Center. So this is what is needed. In India also, we have to think, if we want to, as I said, when you say charting the right course for business, this kind of dispute resolution system has to be there. And COVID has taught us something more, online disputes. Now, not only courts, and there is a talk today that even when we go back to normal, and we are going back, but there should still be, we should continue with hybrid system. As far as arbitration is concerned, it is even now 95% arbitrations are online, because it's not only, and they are happening smoothly, because they save lot of time and cost as well. When you have to go, I've done few international arbitration completed where I am from India, one arbitrator from Australia, one arbitrator from England, Indian party, Singapore party, this one party from British, expert witnesses from Spain and US, and other parts, and all from their own places sitting. Otherwise, how much time and how much cost would have been there if all of them would have been in Singapore, because it was SIAC matter. You can understand, and sitting there for 2 weeks. So therefore, online and technology has today. What I'm trying to emphasize is the use of technology. There's Richard. I've forgotten his full name, who has written a very good book on future of courts and future of law. And he talks that how the courts even are going to be futuristic courts are online courts. And but apart from that, COVID has taught us, and this is happening, ODR, online dispute resolution. Here, online dispute resolution, I'm not talking of arbitration or court. There are certain types of disputes which can be settled through private parties, and such types of parties are coming, or the organizations are coming, which particularly your consumer disputes or MSMEs disputes, etc. And it has been very successful in country like Italy, not Singapore, there's Hong Kong, even in Dubai, and some other Western countries. There was Niti Aayog had set up a committee, and I was the chairman of that committee. It's almost 1 year we had given that report on ODR. So if that is, because for that we'll need law. And if that happens, again, there's going to be lot of difference in how we resolve the disputes or business disputes. So we have to be now, abreast ourselves with what is happening around the world. And we don't have to only see within India and this kind of myopic view. And whatever is good elsewhere, of course, Indian system is different, Indian conditions are different, it has to be adopted to Indian conditions, but at the same time, we have to ensure that good practices elsewhere are accepted here, because when we talk of ease of doing business, when we talk of the enforcement of contracts, and because it is said that if we have better landscape insofar ease of, or better system, and we have this kind of atmosphere where ease of doing business is facilitated, law and this prevail, or rather plays a very, very important role. On the this enactment of IBC itself, I remember we had jumped in international this thing, that when this ranking comes from almost 160 or 150 to 100, within 100 we had come. And they said that you still do not have chapter on cross-border insolvency. If that is introduced, you will again, go up in the ranking. And so therefore, these are the things which are needed. And these are the things which all the lawyers have to master, and you have to take care while thinking that what is the right course for business which we have to chart. Thank you very much.